Good morning. Welcome to the Utah Court of Appeals. We're here today to hear argument in one case. It's State versus Jimenez, case number 20220662. If I could have counsel state their appearances for the record, and we'll get started.
Marion Decker for the state.
Morning.
Melissa Jo Townsend for Edwy Jimenez.
Good morning to you all. You all have appeared in our court countless times, so I'm not going to go into any pleasantries unless you all have questions about how we're going to go forward this morning. We look forward to hearing your argument. It looks like 3 minutes have been reserved for rebuttal. Everybody's squared away on that, I think. So without further ado, we'll turn the time over to you, Ms. Townsend.
Mr. Presiding Judge, and may it please the court, Melissa Jo Townsend for the defendant Edwy Jimenez. Edwy needs a new trial for the 5 reasons we briefed and had in our Rule 23B motion. I'll start with our jury unanimity issue today. The case law in this area has become increasingly clear that it is deficient performance for counsel to fail to ensure the jury is adequately instructed regarding its unanimity obligation. Here we have that, a failure to instruct, which amounts to deficient performance. Moving into the prejudice piece of that, this court has rejected IAC claims on prejudice grounds under 2 circumstances, or in 2 types of cases. The first being where there's some sort of direct and clear identification for the jury regarding which factual allegation it can choose or it can rely on in reaching its guilty verdict, or otherwise some case-specific reasons that have assured this court that the jury was unanimous in reaching its verdict. Now we have neither of those things present here as well. We have 3 distinct factual allegations underpinning, or each of which could satisfy the alleged abuse in this case, but not a direct link made by the prosecution or a special verdict form or anything to ensure that the jury was cabined in its reasoning as it reached its guilty verdict. Beyond that, outside of this direct linkage, we have some case-specific circumstances that were present in State versus Matagian as well as State versus Garcia that aren't present here. In Matagian, we had some indistinguishable touches, which here the allegations are distinguishable based off of location as well as even time of day, which pulls us outside of the State versus Matagian world. And then we have the State versus Garcia situation, which is where there was an accompanying crime, which provided some context clues that otherwise assured this court that the jury was unanimous in reaching its guilty verdict in that case. If there are no other questions regarding unanimity, I'll just move right into our hearsay issue then.
I have some.
Please, I'd love to help.
You knew I would. It seems like this case, one of the most important factors, it seems to me from reading the briefing, at least how you all framed it, was how clear the prosecution was in opening and closing about which count they were maybe trying to zero in on. And the argument we're getting from Ms. Decker is, well, they were clear enough in closing, well, opening and then especially in closing, to sort of clear up any confusion about this. And I guess I'd like your response to that.
My response is in State versus Grenier. I'll point this court specifically to paragraphs 43 to 45. There, this court emphasized that the mere mentioning of a specific allegation is insufficient in closing argument. And this is especially true because we need that direct link, says from the Utah Supreme Court in State versus Pauley, we need that direct link consistently made during trial. And while there was a mere mentioning, I acknowledge that in the closing argument and maybe as well as in the opening, there was a deliberate, repeated solicitation during Penny's trial testimony that gave details about multiple acts that could have each satisfied the single count of aggravated sexual abuse of a child here. That's on pages 602 to 604 of the record, where the prosecutor is deliberately soliciting details about other instances, other locations, other times that this happened, each with their accompanying prohibited touches. And because of that, there is some sufficient ambiguity to lead the jury to at least generally believe that something generally must have happened if there were multiple allegations like that.
Yeah, I mean, the argument we're getting is, okay, great, the evidence came in of these other touchings, the one with the head lice and then the one when she said he came into the bedroom. But the argument we're getting from the state is, well, yeah, that evidence came in, but at closing, the only incident that the prosecutor mentioned, factually, was the first one. What's your response to that?
Again, just that language in State versus Grenier, the mere mentioning, as you just said, Judge Harris, is insufficient. There needs to be a direct and a clear identification that essentially amounts to a limiting of the jury's ability to convict on that, or on that charge based on that single allegation.
So you would need something akin to what existed in the Pauley case, where the prosecutor stood up and said, count 2 is about throwing the gun off the balcony.
Yes.
Like something that direct.
Yes.
We don't want you to consider anything else with regard to count 2. It's just about this. And your position, as I take it, is what the prosecution did in the closing argument wasn't clear enough to meet sort of that standard.
Yes, Your Honor. And the specific language in Grenier that I think is important is, and I don't have it before me, but I'll pull it up on my rebuttal, but it needs to effectively limit the jury's deliberations to that single factual allegation. And again, where there were a multiplicity of allegations made, and beyond the mere mention of the incident in Edwie's bed, the prosecutor also emphasized that this was something that Penny, quote, endured repeatedly, that it wasn't a, quote, one-time thing, that it wasn't, that this was something that happened, quote, multiple times. And so where you have that multiplicity being emphasized, coupled with the mere mentioning of Edwie's bed, that is incongruent to think that the jury is not being limited in the way that's required, at least under State versus Grenier.
And does it matter in this case that we only have a single charge? Because we have only one crime that's been alleged, right? And so does that make a difference in this analysis of how we're examining the evidence that was presented?
2 points I'll make with that, Your Honor. The first being State versus Garcia, where because there was an accompanying crime, a sodomy on a child, in addition to the aggravated abuse of a child crime, there were some context clues that allowed this court to reach the conclusion that it did in State versus Garcia. We don't have those context clues provided in the verdict here, and so it matters in that regard. But perhaps what's even more important to remember is that the conviction in this case, and the reason that it is deficient performance to fail to ensure the jury is adequately instructed, is because what happens is the state's burden at trial is lowered. And so we have a guilty verdict here, a single one, but that verdict was achieved based off of a lower standard or lower burden of proof at trial. And so any weight that we're giving that, it at least needs to be approached or framed in light of the fact that it was easier for the state to get that guilty conviction in this case because of that lowered burden of proof at trial. Now beyond that, I'll just move right into the hearsay issue that we have here. This is a preserved issue, and it has to do with our letter as well as the email that were admitted at trial. I'll focus my attention on the letter here, but the arguments I'll make go to the email as well. The letter was admitted under Rule 801D1B of the Utah Rules of Evidence. This is what the Utah Supreme Court called a narrow exception in State versus Buhan that allows for truly rehabilitative statements to come in. Only that piece of the evidence that is truly rehabilitative can come in. 2 things that I want to point off right off the bat is directly to court's attention to footnote 6 of State versus Plazola. There, this court emphasized that it is difficult for a court to exercise its discretion in a reasonable way if the court has not previously viewed the evidence or read the evidence that it's making the ruling on. On page 665 of the record here, we have an acknowledgement from the district court that the judge did not read the letter before issuing before the debate about its admissibility began.
So just sort of legally and analytically, what is the distinction, if any, between the Buhan rehabilitation doctrine and the prior consistent statement doctrine?
Well, the Buhan doctrine, right, is derived from that rule of 801D1B. Buhan is giving us specific instructions of how that rule needs to be exercised. First, that it needs to meet the threshold standing of the rule, that it needs to be a rehabilitative statement that predates the motive to fabricate.
That's
and
my
is
question, is so all the pre-motive analysis that comes along with the prior consistent statement cases, some of which we've issued quite recently, those apply in that context?
Yes,
Okay, in other words, Buhan isn't sort of a standalone rehabilitation mechanism. You have to go through the prior consistent statement analysis.
absolutely,
Okay.
yes. You need to meet the requirements of the rule first. And then once those requirements are are met, then I think that's where Buhan comes into play, is that, yes, we have something that meets that muster, but when it comes in, it needs to be accompanied by a limiting instruction so that the jury knows for what purpose it can be used. And then it also needs to be redacted or shortened to that truly rehabilitative piece of the evidence.
And so what in the letter is rehabilitative other than the one sentence?
Nothing.
Is that your position?
Yes,
Okay.
yes. And that's also, so I'll turn just briefly to the harm of the letter. Not only is nothing besides that single sentence where she alleges that she was molested, not only is that the single piece that's perhaps rehabilitative if it met the textual requirements of the rule, but all of those things too are not only superfluous, but objectively speaking, emotionally provocative. And those are things that came before the jury and that stood unrebutted to the jury and were not also cross-examined at trial because they came in through not Penny's testimony and counsel didn't cross-examine for
And so as I understand it, it's that would then be your 403 argument, your ineffective assistance 403 argument, that you think counsel should have made a 403 objection to the rest of the letter.
No, Your Honor. We think that it was an abuse of discretion for the court to admit the entirety of the letter under Rule 801D1B. In addition, there is a 403 problem that we have, but that's different from the preserved hearsay issue that we have. So again, I'll point to State versus Plazola. There we had a 40-minute CJC interview that came in under the narrow exception of Rule 801D1B. In that case, this court emphasized that there were rehabilitative pieces of that CJC interview, but the court erred in admitting the entirety of it. That's exactly what we have here. Perhaps there was a rehabilitative piece of the letter, but the court erred in allowing the entire single-space page-and-a-half letter with all of those emotionally provocative details.
I have a question about the procedure, just a procedural question with respect to the objections on the letter, because the state's making the contention that any objection beyond that single sentence was waived, because there was some language about, in the dialogue with the trial court, with defense counsel saying that he didn't have issues beyond that sentence itself. And as I understood your argument in the reply, it was that the waiver didn't occur because counsel was essentially offering a stipulation with the state to redact the letter. And then when the state declined to redact the letter and wanted it admitted in whole, then essentially what happened is that defense counsel's objection was overruled by the trial court. Am I understanding that correctly? I have to admit it seemed a little bit confusing to me as procedurally how it occurred.
I'm happy to clear that up. So first I'll point the court to 672 to 676 of the record. That's that whole exchange about the letter. It begins with an objection to the entire letter based off of hearsay, and thus begins the sidebar there. Within that sidebar, there's quite a bit of discussion about more than just that one sentence. There's some discussion about a misspelling within that one sentence, but counsel calls the entire letter a bomb, and there's a lot of back and forth about the entire letter. At one point, this is an important distinction from what you just said, the court is the one that offers the stipulation and says, counsel, would you be willing to, cut your objection to this piece? And to which counsel, offers that, but the state rejects that stipulation. And that's significant for two reasons. The first being that it was rejected, meaning that the attached ruling that came from that point meant that that the court was ruling on the entirety of the letter, the original objection to the entirety of the letter. But the second reason that's important is because the court was the one that offered the stipulation, meaning that the court was aware that the letter or the original objection was not to that stipulated piece that it was seeking. Does that make sense? The last thing that I'll just close with on the hearsay letter, just due to my time, is that I think it's equally likely, based off of this entire exchange, and also how counsel was viewing the entirety of the letter, that it was in its whole a bomb, that one sentence may have come in under Rule 801 D1B. I think we can read that exchange being that was the stipulation, that maybe that one sentence but not the rest of the letter comes in. And again, the prosecutor is saying, no, we want the whole letter to come in. And that's what we have, the preserved attached ruling there.
So with regard to the one sentence, did counsel stipulate that away?
I think from the reading, from the record, we can see it either way. There's just a lot of back and forth between the prosecutor and counsel there. But I think either way that you read it, whether the stipulation was for only that sentence to come in or for the whole letter except that one sentence to come in, the important thing is that the state rejected that and the court issued a ruling on the entirety of the letter.
So what's your position on the one sentence as you stand here today?
On the one sentence of
Yeah.
whether it's admissible or not
Yeah.
admissible?
Under Buhan and 801 D1B.
Under the text of 801 D1B, it fails because it doesn't predate the motive to fabricate.
Which,
And then-
what do you identify as the motive?
The motive to fabricate, which is, that's the one that counsel asserted during trial, and that is essentially that Penny finds herself in the midst of a split family with step-parents that don't agree and with parents and step-parents that don't get along. And amidst that family feud, she needs to essentially take a side. This letter came years later, and it came after her alleged disclosure to her mom. And so that is the motive that it needs to prefabricate is essentially the splitting of the family and the family drama.
If I recall right, the argument from the other side is that there was also the suggestion at trial that at the CJC interview, she had a motive or was urged to fabricate, and that this predates the CJC interview.
And because it predates the CJC interview, it comes in that regard. The motive or that discussion in the CJC interview, I think, is stemming from the phone call that came right before the CJC interview. Even though I think that the distinction I will make is that that's the same motive. It's the same motive to fabricate, is that this family is having problems and that Penny is in the middle of it and needing to choose a side, essentially. I think that it's maybe just different verbiage, that was a repeated motive to fabricate that was regurgitated during the CJC
We don't hear
interview.
much about any infirmities in the CJC interview from defense counsel until closing argument, right?
Infirmities in terms of its.
The argument being made that there was in terms of motive to fabricate. At closing argument, as I recall from the record, defense counsel made the argument you're making now, which is there was a motive to fabricate because there's split family, two different sort of camps in this family, and one camp is trying to say one thing and one camp saying another thing, right? That's one thing. But then at closing argument, I think defense counsel expanded on that and said, well, there were infirmities at the CJC interview as well. The CJC interviewer pushed her to go places that, in other words, there was flaws in the CJC interview that caused the complaining witness to say what she said, and that is the motive to fabricate. Is that not the argument, at least an argument made by defense counsel at closing argument?
The language that defense counsel uses there and is how I understand his argument being made there is that he's attaching it to memory, and he's also attaching it to not necessarily a motive to fabricate, but an inconsistency in her testimony, that she described it this way during the beginning of the CJC interview, and then as she is continually asked questions, then she specifies and details or gives other details during the thing, or during the interview. And so in that regard, I think it's more of a attack on the inconsistency that's happening in the CJC interview, rather than saying that, you know, she has a motive to fabricate what she said at the end of the interview based off of her interaction with the interviewer herself.
And I'm not sure that it's motive to fabricate as much as an influence to fabricate, that would also qualify under the rule, that the CJC interviewer influenced her to fabricate.
That does qualify under the rule, and perhaps that is an argument that counsel was making. I don't read his closing argument to be that way, but I'm happy to review it at this time and come back.
Just for the record, the letter to the teacher was written before the CJC interview.
Yes,
Okay.
I believe so, but I'll double check that.
Yeah.
My time is out, but I'm happy to respond more during rebuttal. But for these reasons, we'd ask this court to reverse.
Yeah, we've been keeping you over. We appreciate your patience with our questions. You'll have your full rebuttal time. Thank you.
Thank you.
Ms. Decker, your turn.
Thank you. I'll begin where we ended with the hearsay question, and let me just clarify off the bat that the letter was written after the CJC interview. In the first line of the letter, she says the DCFS investigation has already kicked off, and we know that and so this is a couple of months later, and we know that the CJC interview occurred the day after the email was received that prompted.
Yeah, so it
The
was the
DCFS
email to the
investigation.
counselor that prompted the investigation, but the letter to the teacher came later. Is that what you're saying?
Yes,
Okay.
yes.
So help me understand then, what is the premotive issue here?
Well, according to the defense for the first time in their brief, it was the divorce that happened. That's the motive, that all these things have to predate, but Green says you don't have to rebut all of the motives, and during closing argument, as has been discussed, defense counsel made the argument that the CJC interview prodded, and suggested for an hour and 15 minutes until he finally got her to say the word penis. And so there's the motive to influence there.
Right, but that would only be premotive only one of the email and the letter is
Right.
premotive. So
Right.
this argument doesn't apply to the letter, it would only
Well-
apply to the email, right?
Well, but let's step back and look at that. There's nothing different in the letter than what was said in the CJC or the email. So it's kind of, she's already consistently said that before the CJC interview, that I was molested by my dad or my stepdad. And she says nothing different than that in the letter. So, but yeah, that's that. But the state's primary argument to the letter is that it was affirmatively waived when counsel said, I don't object to anything in that letter besides the statement that I was molested by my stepfather from the time I was 7 until I was 9. He didn't care about the rest of it. And it's clear from when you look at the pages that counsel's asked you to look at, that he's concerned about statements about molestation. He's not concerned about the other traumatic events that the letter describes. And as this court's recognized, there's a strategic purpose for that. He doesn't make a 403 objection to those inflammatory statements as described by the state, because he's going to affirmatively rely on those in closing argument to suggest there's an alternative explanation other than that she's been molested by Mr. Jimenez for her cutting injuries and her depression. It could stem from the chaos and the trauma and the drama of living in this home with mother that's asking these things and not providing the food and endangering the pets and such.
So,
Yes.
I have to admit, I'm a little more confused now about what
Okay.
happened with this objection. So as I understood it, counsel made a broad objection to the letter across the board initially, right? I object to the
hearsay.
letter coming in, hearsay, all of it.
Yeah.
And then there's the sidebar, and it's the state's position that during the course of the sidebar, counsel limited the defense objection to the single sentence. And did counsel do that as we've been told here by appellant's counsel in response to a proposal from the district court, or was that something that counsel offered up through the course of the discussion?
That was sui generis from defense counsel. Hey, look, I don't object to any of this except this one statement. And then the court says to the state, will you take that out? No. Okay, well then I'm gonna have to rule on this one statement, and it's gonna come in because I think it's rehabilitating. When counsel's talking about this, defense counsel, He's concerned about statements about molestation. And he doesn't walk that back when the state says, well, I'm not gonna take that out. And he's already said, I don't have any objection to these other statements, so they're off the board. It was incumbent on counsel to then say, well, okay, if the state's not gonna take that out, then I don't want any of the letter in. He doesn't do that, and we know why he doesn't do that, because he's going to rely on that and expressly refers to one of the incidents described in the letter, the death of a pet, as an alternative cause of the cutting injuries and the behaviors, the depression that was observed in the victim.
At the end of this exchange, what did the trial court think he was ruling on?
I was molested by my stepfather from the time I was 7
Just the
until I was
one-
9.
Just the one
Yeah,
line?
because he's already said, I don't have any objection to these other statements. And the trial court's not gonna sui sponte exclude statements that defense counsel said he doesn't have any objection to, because that risks interfering with defense counsel's strategy. And again, as we see that plays out throughout the course of the trial, when he says there's other causes for what happened, for her behaviors here, and motivations for what the allegation is. It's these traumatic and the drama of living in that home, apart from having been molested by her stepfather for several years. But again, the state's primary argument on the letter is that it's affirmatively waived, and that both of them are, the hearsay objection did not preserve the argument that's made on appeal that they didn't predate a motive to fabricate. There was no discussion of when that motive arose or why, and if had that happened, we would have been able to pin down these details more. So that part, it's unpreserved, and that's their claim on appeal. Regardless,
But what the court did rule on, even according to how you're interpreting that exchange, the court did make a ruling on the admissibility of that one statement.
in the letter, yeah.
In the letter. But we've established today that letter was written after the CJC interview, and there isn't really.
But again, that part of that was not preserved. That's the state's position, that they never said to the court, oh, well, that can't come in because it didn't predate a motive to fabricate. The court never had an opportunity to consider that, to nail down, okay, when was the motive? When did these things come in? What happened? That was never, so we think that's unfair to the trial court. That's a first principle of preservation. Did the trial court have an opportunity to address it? No.
Is this because the original objection was just hearsay?
Hearsay, just a broad hearsay. So the letter is affirmatively waived.
Well, but
Neither of them were preserved.
On what basis did the court admit it? The court didn't rule it wasn't hearsay.
That it was rehabilitating, and that was the objection below, that it was not rehabilitating, but they never pointed out the argument they're now making on
Right.
appeal.
But that goes to the question I asked Ms. Townsend, is this Buhan rehabilitation stuff, does that encompass the 801D1B inquiry about pre-motive, post-motive stuff? And she says yes. What do you say?
I think it does, but you need to alert the trial court by never saying, hey, look, the reason this doesn't come in is it doesn't predate a motive to fabricate. They didn't give the court a chance to, he's assuming that it does, that it's properly admitted because they don't say that it doesn't, if that makes sense. He never gave the court the opportunity to explore why they're now claiming on appeal he got it wrong. He didn't get a chance to look at that. As far as he's concerned, all they were saying is that it wasn't rehabilitating because they hadn't shown that that she had denied the molestation and now she was claiming it. His argument below was, I'm just pointing out inconsistencies. She doesn't need to be rehabilitated. There was no discussion about predating a motive to fabricate.
So we're talking about the right case law and the right, I guess hearsay is not really an exception, it's a exemption. We're talking about the right rule subsection and the right case law. We're just not talking about the right.
They didn't alert the trial court. This is the specific thing that's wrong with this. That comes up first time on appeal. That's unfair to the trial court.
The key language in our case law is distinct legal theory, I think. And I think that
Distinct
you're
legal
saying
theory,
that-
yeah, I think that's,
that pre-motive or not pre-motive is a distinct legal theory. Is that?
I think that's
Essentially.
right. That the trial court never had they never alerted the trial court, this is the piece of the rule that they're not meeting, and you need to resolve that. And so we never have that discussion. Regardless, in the end, there's no prejudice here. These statements are cumulative of what the jury's already heard in more graphic detail from the victim herself on the stand when she describes what occurred over the course of these 2 years.
But aren't there a lot of statements in the letter that only come in through the letter?
Yes,
I mean, it seems
Yes.
like there's so they're not cumulative.
no, but they're used by defense counsel to provide an explanation for why someone, other than having been molested by Mr. Jimenez, why she would cut herself, be depressed, have these behaviors, and make this allegation. It's not because she was molested, it's because she lives in this home with this mother.
So is it the state's position then that defense counsel sort of switched strategy midstream after losing the objection? Because counsel did object initially to keep the entirety of the letter out.
Okay, let's back up.
Isn't that clear?
The state wants to present the letter, defense counsel says hearsay, and then they get into a more refined discussion, and it comes out, what he's only really concerned about is the molestation statement. That's all he cares about. He's not concerned about the other stuff. He never makes a 403 objection, and he affirmatively uses it. Trials are fluid. Okay, if he wanted to get the whole letter out, maybe he did change his mind. Maybe that was his strategy from the beginning. He says hearsay, then they have a bench conference, and okay, what are you really concerned about? Well, it's just this one statement. We don't know that when he said hearsay, he was intending to get the whole letter out. The bench conference refines that broad objection.
So as I understand the state's position, the objection to everything in the letter but the one statement is waived or not preserved, or whatever word you want to put.
Affirmatively waived.
With regard to the one statement, the state's position is no prejudice, essentially.
Right, well, they lost that, the trial court correctly put it in because we think that part was waived, and there's no prejudice because both of those statements, the statement in the email and the statement in the letter are cumulative of what the victim has already testified to at trial, and without the graphic detail. And she's already explained as regards to the email what she meant by rape. She didn't understand, she was so young, she didn't understand the difference between molestation and rape. She's embarrassed about it. They talk about that at trial, so hearing that statement is not surprising to the jury. She's already explained, I didn't know the difference.
Can we get over to the unanimity issue while
Sure.
you've still got some time on the clock, and let me hear your position on that?
Our position on that is that competent counsel could reasonably conclude there was not a need for a unanimity instruction here, and in fact, it might even be a bad thing. The state has already said pre-trial and in opening statement and throughout trial, they're focusing on the first in this undifferentiated series of molestations that occur in Mr. Jimenez's bed. Counsel doesn't want a unanimity instruction for the jury to be going, okay, which one do we believe happened? Parsing through them. He's got an all or nothing defense. She's a liar, she misunderstood, or she's been manipulated to have a false
Well,
memory.
But in many of the other sort of dozen-odd cases we've got on this topic now, they're running an all-or-nothing defense.
Right?
And our cases, Matavian, Garcia Lorenzo, a bunch of the other ones, I mean, those are just the ones that pop into my mind. Those are all-or-nothing defense cases too, and we still held deficient performance. So that can't be enough, right?
It helps here, but we also have the election. I think this case is not like McLeod, but like McLeod. The prosecutor doesn't muddy the waters by, in closing argument, introducing these other incidences that were brought out in the direct examination. And let's just look at the context here. On direct examination, the victim testifies about the molestations in the stepfather's bed over 8 1/4 pages. And then some stuff comes out about the lice check and the incident that may have happened in her room, and that's 3 pages. It's never referred to again by defense counsel, by the prosecutor in closing argument.
Well,
Nobody
I-
ever
I-
brings up
I-
those
I-
instances.
Obliquely it is, though, where the prosecutor says, I don't have the page in front of me, but the prosecutor says something like, this happened, the prosecutor mentions the first instance specifically and describes it, and then says something, but that's not the only time this happened multiple times, and says something about the through line through all the episodes is, and starts talking about the common thing that was there in all 3 episodes that I don't really want to talk about right now, but you know what I mean. Isn't that enough?
When the prosecutor's talking about this in opening statement and in closing argument, he uses descriptors of the incident that occurred in Mr. Jimenez's bedroom. He pulled her and he hugged her into bed.
Could I read that part? Because I do think that it's not as
What
likely
page?
as page 916 of the record, which
Okay.
is what you cite in your brief as the
Okay.
key page.
You
And I
want-
apologize for that there is some detail here, but has her in the bedroom, not specific about which bedroom initially, the bedroom and he's spooning with her and so forth. And he's doing this back and forth. What else could he be doing? And immediately after that says, and mind you, this wasn't a one-time thing. You know, this wasn't just a misunderstanding. This happened multiple times. He would use a hug to get her in bed. Now that seems to be referring
That's
to
his
his
bedroom.
bedroom. And he talks about the details of what would happen that were consistent with all of the events. So we know through all of that, he then says. So he starts, it seems like, broad in the bedroom, and then goes even more broad. This wasn't a one-time thing. He gets back specific to his bed and then goes broad again through all of that.
Well, again,
How does that tell the jury we're only talking about the one when we go broad, broader, narrow, broad? And that's all that we're really pointing to in closing argument.
the only time the lice check and the incident in the girls' bedroom are mentioned is during direct examination, and compared to the time that's spent on the undifferentiated series of molestations that occur in the defendant's bed, it pales in comparison, and they're never referenced or explored by defense counsel or the prosecutor again. And so when he's saying the bedroom, the jury's gonna understand
It's
it's
not a-
the defendant's bedroom, and then he only uses those descriptors that she used,
Can I
hugged
add-
and pulled her.
It does seem notable to me that in the prosecution's closing argument, what we just read is the only time that an undifferentiated mention of in his bedroom happens. And it's right in the milieu of mentioning everything. Because they concentrate on, the prosecutor concentrates on the consistent rubbing, breathing, which is consistent with his bedroom, her bedroom, and lice.
Okay, let's back up again.
And really only in this one instance narrows in and
Well,
says hug to get her in
And before you
bed.
respond to that, let me throw on page 939 of the record, which was close, rebuttal close. The prosecutor says something very similar to what Judge Luthy's been talking about. It says, rebutting the argument defense counsel had just made that the complaining witness was misremembering. The state's attorney says this wasn't just one incident. This was a pattern over a couple of years. This was something that she endured repeatedly. And also, as I said, the part that never really changes is that he was doing a particular act all three times. And that act is mentioned. Again, I don't want to get into it here, but again, it seems like, again, the prosecutor is tying all three of these events together as a way to put that in front of the jury that this happened. And so respond to Judge Luthy's question sort of with both of those record references in mind.
The last one is the one where he doesn't specifically reference the hug, but he's referenced the hug and the pulling in the opening statement, and he's referenced it at 9:16, which is also his closing argument, that he hugged and pulled her into bed. Those are things that only happened in his bedroom. He didn't have to hug or pull her into her own bed because she was already in there. But if you look at her testimony, even she's unsure that the one in her bedroom occurred because she thought she might be dreaming. So if a jury, and again, we're running an all or nothing defense, if a jury is given a unanimity instruction, what's the likelihood that they're gonna settle on that one as opposed to the one that's been concretely hugged and pulled her into the bed, that bed? That's where the bulk of the emphasis has been in the direct examination. It's where the prosecutor has remained throughout. The defense counsel never distracts from that. He doesn't reference a lice check. He doesn't reference the one in her bedroom in closing argument, in opening statement, ever. The jury, and she testifies, this is what happens again and again and again. She describes the first one in detail. It happened after school repeatedly. The jury is aware of that, and when he uses descriptors that only occur in his bedroom, there's no confusion here, and he doesn't bring in the lice check or the one that happened in her room. He's focused on that, and so when you get to the 939.
Except that he does, not by saying lice check or her bedroom, but he does say this wasn't a one-time thing. And through all of that, he doesn't differentiate that I'm not talking about those. He kind of swings the door open and look at all of it that happened.
And I think a jury would understand he's meaning the repeated molestations that occurred in the defendant's bed, consistent with her testimony and his focus. If there are no further questions, the state would ask the court to affirm.
Okay, thank you, Ms. Decker. Appreciate your argument. Ms. Townsend, rebuttal.
I'll start with the preservation with the letter and then conclude with jury unanimity briefly. Just want to read a couple portions of the record. So the hearsay exchange, pieces that I think are important. We have a
Which page are you reading from?
I'm sorry, this is on page 672 of the record.
Thank you.
We have, the general letter is being introduced. There's a general objection to hearsay. Immediately, the prosecutor says, the rules of evidence allow an exception to hearsay to rebut the allegation if there's been a recent change in testimony and to rehabilitate a person's characters for truthfulness. The purpose is to show that she's been consistent. So we know that we're in the Rule 801 D1B right off the bat there. That is narrowing the court's attention to that. I want to read now from page 672. This is something that defense counsel says. He says, this is a single-spaced page-and-a-half letter, referencing the whole letter, out of which apparently the single sole issue is a misspelling of one word. I don't think that's rehabilitation, and if they had, I don't see how this rehabilitates an attack on Penny or of this witness. There's nothing specific enough. And then the last thing I'll read is on page 676, which is the court's stipulation here. I believe that there was a question of whether that stipulation was offered by the court or by the prosecutor or defense counsel. And so there's a lot of inaudibles preferenced here, but defense counsel says, I got molested when I was 7 up until 9 by my stepfather is the most important part. There's another reference, maybe not, but that's the most concerning. The court says, okay. Defense counsel says there's a lot of stuff about, and the court says, so you're saying that if that were taken out, you would have no objection to it. Defense counsel says, I don't. Is the state willing to do that? Says the court. The state says no. And then the ruling is based off of rehabilitation there. So that's
I think you have to go back the one
a little bit further.
to 675, and admittedly, there's some unintelligible there. But defense counsel says, I would have no objection to this if he took out the references to unintelligible and then another unintelligible. But the court then clarifies, what specifically are you talking about? And I think we get that unintelligible filled in. I got molested when I was 7 up to 9 by my stepfather. Don't we have there in saying, I would have no objection to this if he took out the reference to, and then he specifies that one line. It seems like that wasn't the court saying, here's your stipulation. It seems like that's defense counsel saying, I would have no objection if that line were taken out.
2 responses to that, Your Honor. The first is that I am sorry that there are unintelligibles here, but there are plural unintelligibles. Also on the next page, he says that that's the most concerning part, and then he says it's a bomb. And I think that it's sufficient here to understand that he's referring to more than just that. That, yeah, that's the most concerning part, but there are other pieces too that are a problem.
The court then, even the court's own wording doesn't make it the court's stipulation. The court doesn't say, well, how about if we took everything out? The court is asking a clarifying question. So you're saying that if that were taken out, you would have no objection. I don't. How does that make that the court's suggestion?
I think that just because ultimately it came from the court, perhaps that's where counsel was going to, but the most important thing to remember as well is that the state didn't stipulate, and therefore the ruling is attached to the entirety of the letter based off of a failed attempted stipulation, be it from defense counsel or from the court. What I want to I'll also just mention too is with the harm. The state didn't brief or address our arguments about harm with the admission of the letter. And just recently this court emphasized in State versus Stubbs that means that we as the appellant have a lower burden of persuasion to establish harm on appeal. And we'd ask the court to look at the letter and the letter's harm under that lowered standard of proof at the very least. The last thing that I'll mention is just with jury unanimity. This is paragraph 45 of State versus Grenier. And it's that whole exchange that there was a strong discussion with during the state's argument. But ultimately, the court concluded that the prejudice there was not cured because quote, the prosecutor did not tell the jury that it was limited to considering only that specific allegation of rape in State versus Grenier. That's what needs to happen, is that the prosecutor needs to limit the jury's deliberation to a specific instance of the alleged act. And because that mere mentioning, as well as the ambiguity and multiple times and multiplicity emphasized during the state's closing in particular, that did not cure the jury unanimity problem that we had here. For these reasons, we'd ask this court to reverse. Thank you.
Okay, thank you, Ms. Townsend. Thank you, Ms. Decker. We appreciate the briefing and the argument in this case. It's been very good, and we appreciate you coming down here today and helping us understand this case a little bit better. We'll take this matter under advisement, as we almost always do, and we'll issue a written opinion as soon as we're able to do so. Thank you for your argument today.